go ahead and call the advisory board meeting to order. And I would like to do roll call. Irma Gutierrez.
Present.
Grace White.
Present.
Matilda Ladner.
Present.
Ada Moreno Brown.
Present.
Leanne Skinner.
Present.
Susie Weems.
Present.
Nisha Weems.
There's another one?
Okay. And then with the other is a vacant position. So we will validate that we do have a quorum.
Yay.
So we have Susie wondering who Nisha Weems is, and she doesn't know she has a long-lost relative somewhere. But I guess this is our new board member that we've not had the pleasure of meeting yet. All right, very good. So we will certify that there is a quorum. Okay, so if you see on your agenda item C, we're going to pass over that since we'll defer that to the next meeting when our new board member is in attendance. So approval of the minutes. Has everybody had a chance to review the minutes? Do we have any changes or modifications? All right, do I hear a second to approve the minutes?
I second.
All right, all in favor?
Aye.
Any opposed? All right, we'll go ahead and approve those minutes. And it says May 3rd, 2018. I thought I had a record of,
This is David Gonzalez. If I could get you to repeat who approved and seconded the motion on the minutes?
repeat it?
Repeat the names so that we can make
Oh,
sure
I'm
and get it for the
sorry.
record. It's okay.
All right, Irma Gutierrez, seconded it.
Thank you very much.
All right. So,
Who made the motion?
that's what it is. Nobody seconded. You made the
I
motion.
made the motion, but I seconded. I thought somebody had motioned.
We're so confused.
Oh, well.
It's okay. It's been a little bit since we
I
met.
can do one of those, whichever. Leanne Skinner.
I make the motion.
I'll second it.
Thank you very much.
So, I have a question. I have an advisory board agenda that we had from September 2019. Why are we approving minutes from May 3rd, 2018?
Yeah, that was the
Mary Winston, TDLR, we did not have a quorum.
Okay,
And so we take no action, so there's nothing to vote on.
okay, there you go. So there were no minutes from that meeting, no quorum. Okay, sorry, just. All right, so we don't have anybody signed up for public comment? All right. So now let's get into staff reports. So the first one is the licensing division.
Good afternoon, advisory board members. My name is Leonard Rivas. I'm with the licensing division. In your packet, you should have the licensing numbers with the fiscal year 2018, 2019, and then the numbers for the first quarter of 2020. So far for the first quarter, you can see that we've issued 196 new licenses. We renewed 728. And the current population, as of the first quarter, is 6,212. Does anyone have any questions about the report? Or questions in general about the application or licensing process?
So 6,000 is up just a little from
Just
our
a little
last
from the,
number?
yes.
Okay, very good. All right.
Anything else? No?
Thank
All
you.
right, thank you.
Okay, our next our next staff report is the customer service division.
Good afternoon. My name is Dawn Robinson. I'm with the Customer Service Division. In your package, you would see the dietitian customer service contacts from fiscal 2019 and the most recent from fiscal 2020. Year-to-date, as of November, we have 129 emails and 158 phone calls. If you have any questions, I'll be glad to assist.
How many phone calls? I'm sorry.
158.
Now, do you track what typically those phone calls are concerning?
Yes, we do. Primarily, mostly it's license status, one to get status of their renewal or their initial applications are our main ones. And then sometime a Versa logins is one of our second biggest.
All right. Anybody have any questions?
Any questions?
Were there any complaints?
I don't know if we've tracked any complaints. I don't know if, what that number is would be on complaints. I can find out and try to get that back to you. Hopefully none, yes, ma'am.
Thank you.
Thank you.
All right, appreciate it. Enforcement Division?
Good afternoon, board members. Happy New Year. My name is Jessica Hurtado, and I am a prosecutor in the Enforcement Division. In your enforcement report, you'll see we've got a little, or about half a page of paragraph explaining our criminal history evaluation letter procedures. Basically, this is a procedure by which someone who wants to obtain a license can go ahead and ask the department to review their criminal history prior to them attending school or investing a lot of money in their education, if they're, at the back end not going to be able to qualify. And so this gives them that opportunity to get the department's position before they invest those resources. And you can see that we have 90 days to do those letters, although we do try to get them out in 30 days. And we do honor that letter as long as there's not anything else that we uncover, later on when they actually apply. And also, if the letter says that they're ineligible, they can always go ahead and apply regardless and go through the whole process of trying to get the license through the whole due process procedures that we have for that. And you can see there that for your program, there were some criminal history letters that were issued, and it was 6 letters, and they were all deemed to be eligible. Any questions about that? Okay, then you can see also the statistics for the program. Through the current fiscal year, we've opened 2 cases and resolved 2 cases, and there have been no final orders for this fiscal year. Any questions?
So is the dollar amount for TDLR, that's the licensing division, that's nothing with the dietitian?
Correct, that's for all the other programs.
All right.
Okay. Okay, if there's no other questions, thank you.
All right, education and examination.
Good afternoon. I'm Fanny Pringle with the Education Examination Division. Start off, we have some personnel updates, some recent personnel updates. As TDLR has grown, E&E has restructured our organization to accommodate our workload and to better address the education examination needs of our regulated communities. To this end, E&E has created 2 new sections and hired 2 managers to lead them. Michael Ford Strawn, he is the new manager of the Outreach, Audits, and Policy section, and Angie Schmidt, who could not be with us today, is the new manager of the Training and Accreditation section. In reviewing our statistics, the jurisprudence exam numbers track with the initial license and license renewal number trends. The numbers are current through December of last year. The continuing education audit numbers reflect the number of licensees identified and selected for audit during the corresponding time period. E&E utilizes a computer-generated random drawing of 10% of the licensed monthly renewal population. Licensees had previously been selected 60 days in advance of their license renewal expiration date. However, as of November, we've extended that time period to 90 days, and So now they're selected, identified, and notified 90 days in advance of their expiration date. And therefore, there were no audits conducted for December and January of this year, but they will be caught next year. Are there any questions you have for me?
So, just out of curiosity, so these are the number of audits that you're performing?
Correct.
Are they pretty much, you find that people have accounted for their continuing education hours appropriately?
What E&E identifies the people for audits, and we notify them. However, it's the licensing division that actually conducts the audits. It's my understanding that it's taking 2 to 3 days from when they receive the information to process their renewals for those persons with audits. However, if the persons being audited don't have their required certificates, they're not being. That adds to the time lag.
Leonard Rivas with the licensing division. For the most part, people do have the continuing education hours required. However, we still have a few individuals that are waiting longer to submit their information. So it does show that their license is expired in the system. But yes, for the most part, they're complying with the CE audits.
Great, okay. Just curious, you know. Okay, thank you. Thanks, Leonard. All right, Regulatory Program Management Division report.
Good afternoon, board members. My name is Mary Hoffman, and I'll be providing the Regulatory Program Management Division report for you. I have brought up Stephen Eager with me. We'll touch briefly on the Senate Bill 1264 balance billing item that just passed this last legislative session. If there are any questions, Steve is here to assist. Okay. An update on dietitians program activities. Medical and health professions section continues to help customer service and licensing with emails, application, questions, things of that nature. Our staff is also continuing to work on BIT teams. Those are bill implementation teams, and that is implementing changes from the legislative session that just ended. So we'll continue to work on updating web pages, applications, and forms for those programs. And TDLR has just issued the guidance statement on Senate Bill 1264, and all of you should have received that as a handout, not in your meeting materials. And what that is that's a bill that was passed last legislative session, and it protects consumers from surprise medical bills in emergencies and cases where the consumers don't have other options. The bill prohibits balance billing by out-of-network providers to state-regulated insurance enrollees. A balance bill is defined as a bill that exceeds the applicable co-payment, co-insurance, deductible, and deductible under the enrollee's health care plan. Enrollees cannot be balance billed for emergency services provided by non-network facilities and providers, emergency services provided at an in-network facility by a non-network provider, or in situations where the enrollee does not have a choice of providers in an in-network facility. The bill also provides an exception for non-emergency care. If the enrollee chooses to use an out-of-network provider for non-emergency care, the enrollee must sign a waiver, basically waiving their rights to the protections of the bill. The bill also authorizes TDLR to adopt rules and take disciplinary action for TDLR's licensees that this bill applies to regarding any violations of the balance billing. And I can go on and read the rest of this, but basically this bill applies to only about 16% of Texans, which is 1.1 million Texans. that are enrolled in the state-regulated health plan. And those are health plans that are regulated by Texas Department of Insurance. And on those insurance cards, it will say DOI or TDI on the insurance card itself if they're a part of this plan or this network. Also, this bill covers employees' retirement system enrollees and also teachers' retirement system enrollees who are enrolled in TRS Active Care. This really impacts providers who are working in facilities and providers that work in diagnostic imaging, emergency care facilities, laboratories, and that also bill individuals that are enrolled in these plans. So if you are not working in a facility and don't plan to balance bill, this wouldn't apply to you or impact you. And so in the document that you have, you'll see the definition for facility, and you can read that. If you have any questions, feel free to let us know, and we can try to get some clarification for you if something's unclear. The status of the bill went into effect January 1, 2020, and that applies to services or supplies provided on or after that date. TDI has adopted amendments to the rules and added new sections to the insurance code to implement this bill, and they have also adopted emergency rules as well. And you can find that information on TDI's website. There are also provisions for the waiver. So if an enrollee, and TDI also adopted emergency rules to implement the waiver provisions of the bill. And there is an email address on that document also to TDI if you have any questions regarding the balance billing rules. Any questions regarding this before I go to the rest of my report?
Leanne Skinner.
Yes, ma'am.
I'm curious. For private practice biller dietitians, if one of the people from the teacher's retirement came to our office, then we could bill them?
Well, if they were, so they're enrolled in a state-regulated insurance plan, but you may not be working out of a facility, so you would probably not, the requirements of the bill would not be enacted. So, yes, and especially, I mean, if you were intending on balance billing, in other words, if you intend on charging them more than their insurance co-payment, that would be the only time when it would be implemented.
So I would need to,
So, let's say you have an enrollee and you intend to charge them more than their insurance plan. Then you would have to use this TDI standard unalterable form and give that to them 10 days prior to you providing the service so that they have time to consider paying for that service.
and where do I get that form?
The Texas Department of Insurance website.
Okay.
So Leanne, would that apply since she's not, doesn't fall under the category of facility?
Yeah, but if you're not operating out of a facility, which is a hospital,
Right,
ambulatory
yeah.
surgical center. But it's worth inquiring with TDI because if this person is being referred to you, if this is just private practice, somebody walking in off the street to you, then it wouldn't apply. But the Texas Department of Insurance is still working on implementing and understanding their responsibilities for this bill. And if they were referred to you from a provider in a facility, it's worth asking the Texas Department of Insurance if this balance billing requirement would apply.
There's a lot of private practice dietitians in Texas, and so that is a legitimate question, I think, because I have had people
Of
from
course.
retired teachers, so.
Yeah.
Right.
Now, would it count that the counseling or the therapy that she's giving might not be emergency?
Right, well,
Right. You
it does
wanna call
apply
it-
for non-emergency care.
This is Wendy Pella, Assistant General Counsel. I want to make sure we're not getting into trying to provide legal advice here in different scenarios. I think the important thing for the regulatory program management staff are providing this information to you. These are changes to the insurance code. These are rules that are being adopted by TDI. They adopted some emergency rules because the statute went into effect January 1st, so they needed emergency rules. They'll go through the rulemaking process. I think it's best we wanted to alert you to this because there's kind of this other requirement that's outside your dietitian statute. Want you to make aware of that. But I think it's best to direct you to the TDI website for the form and the questions, because they're probably getting a lot of these type questions from a variety of practitioners as well. So I want to make sure we're cautious of not offering legal advice to specific scenarios on that.
Definitely. Thank you.
Thank you, Wendy. So I'll go on with the rest of the report. Did you have something else to say?
No.
Oh, okay. So for public outreach, regulatory program management staff will host a booth, and I will also provide a presentation at the Texas Academy Annual Conference this year. That will be in Georgetown in April. And for our section updates, medical and health professions staff also continue to work on the TDLR Health Monitor, which is our quarterly newsletter. The most recent publication went out in January, so just a couple weeks ago. You can find that publication on our website and also archived editions as well there. If you ever have any ideas or suggestions for topics to include in our article, feel free to reach out to me and we'll consider those. I also wanted to touch on another handout that you have. There is the Senate Bill 202 implementation report. Senate Bill 202 is the bill that transferred 13 health-related programs from DSHS to TDLR, which you are one of those programs. In that bill, it was required that TDLR issue an annual report on the implementation of that bill, and we have provided the legislature with the final report in December of 2019, and you have a copy of that. I'm available to answer any questions. No? Okay.
All right.
Thank you.
You bet. Thank you all. Executive office report.
Good afternoon. My name is David Gonzalez. I'll be giving the executive office report. We're going to start off with personnel updates. This is probably a new face for y'all on this side of the dais. I have been actually with the agency for 23 years. Brian Francis is the person that y'all are probably used to seeing at the advisory boards. He's acknowledged that he could stand to do with a little bit of help. So what's happened recently is we had a retirement of Miss Carla James. She retired in late November. After many years of service, she did a wonderful job, but she was doing such a good job. Brian didn't realize that he could actually stand to have two people's help instead of just the one that he had. She had some financial prowess, and she did her job hiring a new financial manager for us. So he appointed two deputy directors instead of just the one to replace Carla James. Miss Christina Kaiser, who used to be our director for enforcement, is now a deputy executive director, and I'm even having difficulty saying it because it's still new to me. As of December 1st, I took on the additional role. I was the regulatory program management director. I've become a deputy director as well. So you will be seeing probably more faces interjected into these processes just so that we can relieve Brian of some of the responsibilities that he's been so adept at taking care of. He's got some really broad shoulders, but I think he can have a little bit of help, and we might do okay. We may not be doing quite with the policy he has, but I'm working on that. I'm working on it. So that's our personal updates. Update from the 86th legislature. As you can imagine, for the past actually, I've been with the agency 23 years. We have grown just about every legislative session in those 23 years with new programs and responsibilities. This last session is no different. I won't give you all the details of every responsibility we've taken on because that could take quite a bit of time. But some significant ones, we took over fuel motor quality program requirements from the Texas Department of Agriculture. So all those gas pumps and gas stations and the responsibilities for skimmers that could steal your credit card information, that responsibility has been transferred to TDLR. It went into effect September 1st, but there's a transition period and some responsibilities that are still coming over. That's a huge program for us, and we're still working on the IT aspects and the programming aspects. A lot of responsibilities to take on, but I think we're up to the challenge and really working hard on that. We also have responsibilities for motorcycle safety program coming over September of this year rather. That came over from DPS. And we also were given some monies and resources to help with our anti-trafficking initiative, which is kind of important. It's something that we provided some resources for even before we were charged to do it by the legislature. But they actually gave us monies and resources. We have a new team, and I'm actually going to go out of agenda line to allow Miss Mary Winston to introduce the new team and what their efforts are going to be directed towards.
So the agenda says introduction of the Human Trafficking Prevention Unit. It's going to be a virtual introduction because they're in training downtown, and we're doing extensive training. As David mentioned, we didn't have specific funds allocated to staff this team and provide them with resources. Initially, we had kind of a one staff person who was just handling this whole big old state of Texas, and I like to say as more of a triage. I mean, you have to get your mind wrapped around it to even try to reach your arms around. So now we have a fully staffed team. That one person team from before, Ms. Jennifer Harless. We have Chuck, and Chuck
Winkler.
is going to kill me.
Mr. Winkler.
I want to keep calling him Warner, but people always call me Watson, so I don't know. So Ray Carswell, Jennifer Ignacio, Alex Ortiz, Brian Cottle, Gloria Newton, and Jordan Strain. This is week 3 of training, and we have several. We've had the governor's office come in and the director on child sex trafficking. We are having training on tomorrow for trafficking to identify certain trafficking elements by another resource. I think, can't remember the name of that one. We are going to speak. We were at the Capitol earlier this week talking to some of the legislators or their aides and assistants on thanking them for this money and opportunity and getting more ideas on where we're going to go with this training. Currently, TDLR licenses massage therapy. This licensed body, I love a great massage. I love our massage establishments, but there's a side to this that we've discovered that does incorporate trafficking. And so the legislature is aware of that and afforded us monies to hire an inspection team, a prevention team, and whereas we have our enforcement, and that's complaint-based. So if a complaint comes in, our enforcement team goes out. We have our field inspections team. That's a periodic inspection. This team is going to work hand in hand with both of those and try to fill that gap of inspections where we know this kind of thing may be going on. So we want to welcome them. One day we'll actually get them here, but right now we're just doing a virtual introduction. I don't want to interrupt their flow of training.
David Gonzalez, TDR. I made sure to include this one in our updates for the 86th legislative session because I know Mr. Francis is quite proud of this. We did take an initial effort, even without resources, because we knew we were positioned with our role as a regulatory agency, as a licensing agency, and not just for human trafficking and massage, but for cosmetology and for air conditioning and electricians. We could actually identify and help law enforcement identify those human trafficking efforts, labor trafficking efforts that we could offer some input and help with those investigations. So really proud of those and wanted to make sure that y'all are aware of it because that does add to our workload and other things that we would be working on. So back to item C, the communication outreach statistics. This is something that we regularly provide as information. You may want to be aware of how many people are visiting y'all's webpage and whether or not the information up there is actually satisfying y'all as licensees or the public as licensees. So over the past 6 months, from July through December, the Dietitians website has had 34,771 views, an average of 238 per day. 84% of those visitors accessed your site from a desktop computer, 14% from a smartphone, and 2% from a tablet. The top reasons for visiting the site include administrative rules, exam information, renewing a dietitian license, applying for a new dietitian license, and dietitian's occupations code. So these are things that we would typically see for all of our programs, but if there's anomalies or things that you think would need to be prioritized, maybe we can do a better job, and I would give kudos to our, Josh and our webpage developers to make sure that we're doing our best to focus our efforts and do the best in putting graphics and information out there for the public to use. But we can always get the input from the public to see if we can do a better job. The last two things I'll be addressing, sunset review process. We are currently under sunset review for all programs received prior to September of 2016. So y'all's program, not under review yet. It will be coming up pretty soon. In fact, because we went so long without a sunset review, they kind of delayed it because we were getting so many programs. We're going to be going through 2 sets of sunset reviews in very quick order. But right now, all of our administrative processes, all of our structure, the way we do business is under sunset review, and that's a commission that's got 5 legislative members from the House, 5 legislative members from the Senate, 2 public members. They're appointed to do this job and make sure that somebody's overlooking our agency to see if there's a reason for us to still exist. Are we keeping up with the times and still serving our purpose as public servants? Typically, they do come back and tell us that these programs do need to continue to exist, but every once in a while they'll come back, actually, most of the time, they come back with recommendations of what can be improved and how things could be made better. So we do expect that report to come back sometime in May. We started in October. We've had like 37 meetings with them already, another 13 scheduled in the next couple of months. It keeps us pretty busy, informing them of how we do our business. It's kind of like having a shadow in all of our divisions overseeing our work and asking us questions about how we do things, and it's a good thing. We invite this. This is an opportunity for us. Y'all have an opportunity. The public has an opportunity to give input as well. We've actually got our self-evaluation report published, and it's on their website, www.sunset.texas.gov. It's already out there, our own self-evaluation. But the public has an opportunity to show up for hearings and give their input as well. If they contact you to ask how things are going, how we're doing our business, and whether or not we can do a better job, we want to hear from you, frankly. We need to know, they need to know, so we can get those reports and recommendations put into either management directives from them or even legislative changes that may need to be done. They can actually pursue that, and it can be carried into the next legislative session as statutory changes. So this is a great opportunity for this agency. We get to do it 2 times in the next couple of years, and so y'all should take advantage of it as well. Just wanted to make sure y'all are aware of it. The last thing that's on the agenda is the strategic planning process. So in between legislative sessions, we usually go through our strategic planning process, another process that we are very proud of. I've been here 23 years. There's not a lot of agencies that do it the way that we do it, but we actually go around the state asking for input, giving everybody the chance to be king or queen for a day. If y'all have been here, I think, long enough to maybe have experienced at least the invitation for this process, it is usually well received. Wherever we go, we have smiles on faces. Sometimes we get arrows shot at us. That's part of our job. We're not here to, we're not showing up just so we can get kudos. We need to hear how we can do a better job. So if we can improve things, if you see something in the future that's coming and you can share that insight with us, we need to hear about that. And so that's why we go around the state. We post all the results of the input that we get up on our website, and we use that information to actually determine what we're going to pursue with legislature the following year. If we hear from the public that there's a better job we could do if we had these rules or these statutory changes, we're not lobbying for these efforts, but if the public says that these are things that could help them, we present it for the legislators to consider, and that's how we move forward with our strategic planning process. I'm really proud of that process. I've been able to participate in it for years. I would encourage you to keep, if you're not already signed onto our listserv, make sure you keep signed onto our listserv so that you get those notices when it comes time. And I think that's all we have for the executive report, unless I'm forgetting something. Any questions?
All right, thank you very much.
Thank you.
So we'll move on to agenda item G. This is the discussion and possible recommendation regarding proposed amendments to existing rules.
Good afternoon. I'm Wendy Pello, Assistant General Counsel. This is Agenda Item G, and you have a very long caption. Basically, we are amending the dietitian rules under 16 Texas Administrative Code, Chapter 116, and we're doing that. We're proposing amendments to existing rules. We're proposing the repeal of existing rules, and we're also proposing new rules. And there's 3 categories of changes that we're implementing. We're implementing 2 bills that were implemented or that were enacted this past legislative session, House Bill 2059 and House Bill 2847. And even within House Bill 2847, there's multiple articles and sections within that. That was an omnibus bill that applied to multiple programs. The second category of changes is a huge category with the department staff work with our licensing work group, the Your Advisory Board's licensing work group, and did a lot of streamlining, trying to make the rules more efficient, the process, the licensing process and the renewal process is more efficient, more streamlined, getting rid of unnecessary requirements. And then also in the third category of changes is kind of terminology, what we call terminology and cleanup changes. And it's kind of a miscellaneous category of fixing terminology, removing unnecessary provisions, fixing terminology and cross-references, and then consolidating two subchapters that were relatively small in terms of number of rules into one to make it a little bit more user-friendly. So you've got the proposed rules in front of you, and when you're sitting in the audience, there's copies at the table. So you can see that kind of that overview on that first page of those three categories. With your permission, I'll just kind of walk through each of the sections. We can talk about it if you have any questions. On the draft you have, I've annotated it to try, because there's such a variety of changes, try to say this section, this is a bill implementation change, or this changes the terminology, or it's a combination of things, and try to explain what we've done. So go ahead and get started if you all have that in front of you. On page 1, under 116.2, the definitions, we've added a definition for the Accreditation Council for Education and Nutrition Dietetics, ASCEND. Removed the definition as CPE, which was defined as continuing professional experience, but it's actually continuing professional education. So we got rid of that definition, and then we just renumbered accordingly. And those definitions go from page 1 through 3. Were there any questions or comments? Okay. Page 3 of the rule draft, subchapter C. We actually combined a couple different subchapters. Subchapters C and D we were combining. This was the education and the experience requirements. They were in two separate subsections and only had 1 or 2 rules under each of those, so we've combined that into one subchapter. Under what's 116.20, we just made clear that these are the education requirements regarding degree and coursework. This was an area that we tried to improve the license application process and really tried and streamline this. What we've done is the statute sets out a requirement that to apply that they have to have a baccalaureate or post-baccalaureate degree in a major course of study in human nutrition, food nutrition, nutrition education, dietetics, or food systems management, or an equivalent major course of study approved by the department. And then the current rules set out a detailed list of what was an equivalent major course of study, which had a variety of subject matters and number of course hours and semester hours. And then there's still the catch-all of minimum accreditation that qualifies for examination of CDR. Well, because the way the process is and everyone goes takes their exam through CDR, and you have your transcripts and your coursework and education evaluated there, it's not necessary when it comes to us. You've already met that requirement, so we don't need your transcripts. And so the big change in this is 116.20 is kind of streamlining that, setting out what the requirements are in the statute. This is page 4 under C, so just stating it. And then under D, we're stating for purposes of meeting those requirements, the department has determined and will accept a major course of study that's acceptable to the Commission on Dietetic Registration to qualify for the CDR exam. And then it removes all of that, the details.
Right.
And that makes it easy. And so then when you get to page 5, subsection E, the applicant at that point just needs to provide their active CDR registration number at the time of license to prove that they've met their education requirements. And then the degrees and coursework that are accepted by CDR will be acceptable to the department for licensing purposes. And so then we removed the unnecessary provisions. Any questions on that? Okay. So when we do that, also on page 5, 116.21, we repealed the rule on transcripts, so we won't need your transcripts anymore. Our regulatory program management staff has done a lot of research on this and working with CDR and finding out what they're doing, their processes are, and they do review everyone's transcripts before sitting for the exam. So there's not reason to have a double review of those. They've already evaluated that to be able to they're eligible to take the exam. So That should streamline the licensing process in terms of you all don't need to, or the applicants don't need to send us transcripts, and that doesn't hold up the timing of the licensing process. Any questions on them? Page 6 of your rule draft, this is section 116.22, the experience requirements, internships and professional experience programs. This was also a licensing work group change. This is the section that moved from subsection D. It's all showing up new because it's been relocated. One of the things we wanted to do was to clean up and make clear about and update what the experience requirements that were acceptable. Previous rules refer to and the statute still refers to a pre-planned professional experience program. And we were referring folks to CDR as pre-planned professional experience program. Well, they got rid of that years ago. So there was questions about, well, which program is that? And so it was kind of circular. So folks would come to us and we'd say, well, go to CDR, and CDR's like, well, we don't have that, go to TLR. So just to clear that up, but we also got detailed information about what CDR is accepting in terms of internships, and making sure what they were offering or what they accepted was still within the scope of our statutory authority to accept. And so what you see under subsection B is those types of experience requirements that are either approved or accepted by CDR or ASCEND. And so you've got the dietetic internship, which is you've taken your coursework and then you take your internship. Number 2, which is the coordinated undergraduate program in dietetics, which is the combined coursework and internship all together in one program. We had a good education from CDR on this. 3 was that individualized supervised practice pathway, which our understanding is that's identical to internships, but they're not ASCEND accredited, though they are ASCEND recognized or approved. Apparently there's kind of a limited number of internship spots, and so they've allowed another kind of pathway that's also considered an internship, so we would also count that as possible. And then 4 was a kind of the catch-all of a professional experience program in dietetics. And all of these are, again, in dietetics, and this kind of is a catch-all in case they've developed something that would still qualify that they would approve or accept. And so still meeting with the kind of the professional experience program that's in the statute.
This is Susie Weems. Could
Yes,
I ask
ma'am.
a question?
Yes, ma'am.
Because I thought currently in section A under here that it was not less than 1,200 supervised hours.
Right, and this is the statute.
Pardon?
And this is the statute, and so that's
Okay,
right, the
so we have to
statute.
stay with that irregardless.
Right,
because it
but
will
they're
not
going
be-
to
those other
CDR.
components will not be approved.
Right, and that's kind of the struggle we're having, is how we're staying within the scope of what the statute is versus where the industry has moved.
Thank you.
So that's what that subsection A is a restatement of what the statute requires. And so that's what we're trying to figure, the requirements of what CDR offers and what the statutory requirements are, and trying to make sure we are in compliance with both. And then under C is that the applicant just provides their active CDR registration number at the time of license application to just prove that they've got their experience requirements. So that active CDR registration number is going to serve for a variety of purposes. Any other questions or edits or comments on that? And then subsection D, which is at the bottom of page 6, that's the current experience requirements subchapter, and then the one rule that's under that subchapter is being repealed. On page 7 of your rule draft, under subchapter E, examination requirements, section 116.40, license examination requirements general. We're just streamlining it. Subsection C said the department shall waive the examination requirement if they've already they're already a dietitian registered under CDR. That's out of the statute, but it's a little confusing having the rules since we've already designated the TDLR or the department approved exam as the CDR exam. So it reads a little awkward in there. It's still in the statute. It still applies. But I think it helps streamline the process and eliminate that confusion. Any questions on that? Page 8 of your draft, license examination process. This is 116.42. This we're just clarifying the examination requirements in terms of, again, providing your CDR registration number, proof of passing the exam. Right now, the current subsection D says applicant must provide documents showing examination passage. The only thing we need is what's under the new E is the active CDR registration number. Any questions? Still on page 8, subchapter F, licensed dietitians, section 116.50, application eligibility requirements. This we've done the streamlining on the experience requirements. We've also made some cleanup based on House Bill 2847, that was Article 12, which is getting rid of some language about revocations on that. So under subsection B, right at the bottom of page 8, we're just streamlining, saying to apply for the license, you must submit. And then you can see we've gotten rid of, on top of page 9, we've gotten rid of the transcripts. The current rules say we need a copy of a registration card, which is one more piece of paper or one more copy that you need to send. You get your active registration number to us. Licensing staff looks that up and then can verify that. So we don't need the paper on that. And again, the rules have been streamlined, so because you'll have that active registration number, that's going to show your proof that you've met your education, experience, and examination requirements under there. Subsection C, this is, we're trying to put this in all of our rules. This is putting on our standard criminal history background check language that refers to our chapters 51 and 53 of the criminal conviction and our criminal conviction guidelines. And then subsection E is getting repealed because that section was repealed out of the statute. Questions? 116.51, the fitness of applicants for licensure. This is not physical fitness. This is your fitness to practice. This is something we talked about with the licensing work group and had discussions about trying to update these requirements and make them a little more objective or something that, tangible that we would have proof of, and to reflect the licensing application process. So at the top of page 10, basically in determining the fitness, we're looking at the ability to uphold the standards and requirements and getting rid of skills and abilities. This profession doesn't have at least for the department licensing, there's not a practical exam. There's not a hands-on, show us your skills, anything like that. So that didn't seem to be something we could measure or how we'd have knowledge of that. So that we replaced that with at least something standards and requirements, something a little more objective. And then under subsection C, in terms of what we could look at or what we may request to consider the fitness is any disciplinary actions taken by CDR against the applicants, their registration, any disciplinary actions taken by other jurisdictions, and then still any transcripts from court hearings or orders and any other information. So it's something a little bit more concrete and documented. We got rid of things like evaluations from your supervisor, statements of person submitting references, evaluations of employers. Those are not things that we collect, and a little bit more subjective. So if you have any comments or questions on those. Clean up under D, just saying that these are the following actions may be the basis for determining for denying the application, and then it's the same list, but again, instead of lack of necessary skills or abilities, which we would not have a way of judging that, just whether you've had a disciplinary action against CDR or another jurisdiction. So we've tried to make it a little bit more concrete, something a little bit more objective, and things that we would or could collect information from. Any questions or comments on the page 11 of your rules, 116.53 licensed dietitian license term and renewals. We're removing the requirement of proof of completing the jurisprudence exam for your license renewal. You will still take your jurisprudence exam prior to getting your initial, but this is not a renewal requirement. It will be something you're allowed to take a CE and get a credit for it if you'd like, but it's no longer a renewal requirement. We've also added a new requirement. So when you go to C, we've gotten rid of the jurisprudence exam. What was C3 and 4 about the criminal history background check and the fitness, we've just relocated just to mirror the kind of the structure from the initial applications. You still have to take your CE and provide an audit, comply with an audit if you're selected. So D is just the relocated, you're taking the you must successfully complete a criminal history background check with our references. The E has your fitness requirements. F is a new requirement, and this is from House Bill 2059. This is for each license renewal on or after September 1st, 2020. The licensed dietitian must complete a human trafficking prevention training required under Occupations Code Chapter 116 and provide proof of completion to the department. This, do you have a question you want to explain? Yeah, this bill, it was not targeted to dietitians. It's very broadly written. It applies to healthcare practitioners under Title III of the Occupations Code, which is a very long list of various healthcare professionals, those who provide direct patient care. So this is a requirement from the legislature that they take this course. The course will be approved, and it can be multiple courses. The Health and Human Services Commission will approve those courses. At least one of those courses has to be free, and you'll have your option. They'll post those courses on their website. So HSC, our understanding, they'll be doing rules. They'll be approving those courses. Lots of the state agencies who regulate the various professions are looking to them, and this is something we're putting our licensees on notice, just because this is not something you're going to find in your dietitian statute. It's kind of this other statutes you want to make sure you're aware. Because
Wendy, can I ask you a
yes,
question?
ma'am.
I'm familiar with the course because I still consult for the Women, Infant, and Children program in Georgetown for Williamson County, and we have to take a course yearly with the state. So do you know offhand if those courses would be one of the ones?
That I don't know. They
Okay.
will post it on their website, and as we move along, we'll make sure all of our licensees that are, because we have 10 of our health professions are affected by this, so make sure we keep you all up to date if there's courses up there in their website.
And they're all on the computer, so they're probably easily to be taken.
Yeah, well, it'll depend on if they approve, online courses, in person. It's going to be up to who wants to offer those providers, but that's what the requirement is in. So it's just, and it's a condition of license renewal, and it's a condition for every license renewal. So we may make sure everyone's on notice about that.
Thank you.
And like I said, it's still, a lot of the details are being worked out, so what that looks like in terms of what proof you show us and, what the forms of the courses are, how many hours those courses are, those are still being worked out. But the law does require at least one of those courses to be free. So that's what that new requirement under subsection F is. And then the cleanup is under subsection G. We've gotten rid of what was former E and F and consolidated those and just included the cross-references back to the statute. One of the things I do want to note is while there was cleanup in the dietitian statute under 701.151, getting rid of the requirement that we shall deny for certain violations, there's still a requirement elsewhere in the statute that didn't get caught for, or didn't get made for renewal. So there's still a little bit there. So there's still an exception for renewing the license under 701.401. So it's there. There's kind of clean up there, and those are just implementing the bills. Questions? Still on page 12, subject I, continuing education. We're trying to remove some unnecessary provisions. Under subsection A, we're saying, right now it says licensed dietitians are required to continue education. This was in here back when there were provisional licenses, so now we don't need to say this section applies to licensed dietitians since the whole chapter does. So we've made some cleanup changes like that. That's no longer necessary to make those kind of distinctions. Yeah, and we've made some other cleanup changes about the applicability in terms of when the hours were completed prior to date, because we've got other sections that talk about courses being taken before your license term and courses taken after your license term. Page 13, section 116.81, the approved courses and credits. Under the rules under subsection C, that we're making cleanup changes. Under D, this is where we allow the jurisprudence exam to be taken as part of CE, but again, the jurisprudence exam is no longer required for renewal. Subsection D says we'll grant 1 hour of credit for taking the jurisprudence exam, and then we're just eliminating the requirements under E, that was the jurisprudence. Have any questions about those changes under that section? Okay. Bottom of page 14, 116.82, continuing education records and audits. When we went through this rule, and as Mr. Gonzalez stated earlier, going through sunset, one of those things is sunset, they're always looking at our statutes and rules, make sure we meet the requirements of gender-neutral language, other cleanups, making sure we're using person-first respectful language. And so you'll see some of those kind of cleanup changes here. This profession's not under the sunset review, but we're being proactive, we're seeing those changes, go ahead and making those. So under subsection A, we're making those cleanup changes to gender-neutral language. Also making some cleanup changes and references under subsection A and E from license holder to licensee to make sure it's consistent throughout the section. So that's where you'll see under subsection A, instead of the his, her kind of terminology, make sure we're just saying licensee. So you see those cleanups there. Any question?
Yes, this is Matilda Ladner. Would the time, whether it's an hour or 2 hours of this human trafficking, would that be included as part of that 12 hours, or that's separate?
That will be on our next agenda item H, and we'll be having that discussion. Initially, for this first round, since there's still a lot of questions right now, and it's a condition for renewal, it's a separate renewal required until we get more information, but we definitely have that discussion when we get to H about having it be CE. So right now, it is not. Right now, it's just a separate standalone renewal requirement. Any questions on that? Page 15, under subsection J, responsibilities of the commission and the department. We're getting rid of the rule about the registry. This is a requirement in the statute. It's still there. We're still required to provide it. There's been some changes in terms of the registry, what's published on the website, concerns about public safety and whether people's home addresses are posted there or not. So there's been some changes. So we don't want to lock ourselves into a rule that says we're going to post, information A, B, and C, and then something changes of what's posted. So just rest assured the registry is still available, that people can request that, and it's still a requirement, but we just don't need it in our rules. Again, helps clean up and streamline. Under just page 16, subchapter K, responsibility licensing code of ethics, rule 116.100, display of license. Again, removing the unnecessary section or subsection A, saying this section applies to licensed dietitians. And just the remaining sections are relettered. 116.101, changes of name or address. Again, removing that unnecessary subsection A. And then separating, there's some cleanup in subsection B about notification names must be submitted, getting rid of details like whether it has to be faxed or mailed. There's a lot of, especially as we move to a lot of things that are more online, that people can make changes. And then just making for clarification purposes in this session from licensing in terms of notifying us you can change your name or address, but if you want a new license with your new name on it, then there is the fee there. So separating those two requirements into subsections may help clarify that. Page 17, unlawful, false, misleading, or deceptive advertising. This is section 116.104. Again, subsection A, getting rid of or replacing existing language with gender-neutral language. Subsection B, which is, I think, the meat of this, is getting rid of what was B for containing a testimonial. This is saying, because the rules right now say that a false, misleading, or deceptive advertising, it's not readily subject, includes advertising that's a testimonial. The Attorney General issued an opinion about this provision, and we're removing this kind of blanket prohibition. They've thought that this might be unconstitutional because it's not like, if it's false or misleading, yes, you can get it, but the fact that it's a testimony on its face does not necessarily make it false or misleading. And so that was, and you've got the reference to the AG opinion there, so we're removing that, and we have this in some of our other health programs that came over, and so we're making those same cleanups in those programs as well. And then just relettering the rest of the rules. Any questions or comments on that? Page 18, Code of Ethics. updating the terminology in subsections A and B to use gender-neutral language and use person-first respectful terminology, and then making some updates to the cross-references in statute. So you see, like under A1, you've got removing or replacing language with gender-neutral. Under A8, we've got some cleanups and cleaning up those statutory references, the names of the act, and then with the statutory reference behind that. And cleaning up under, I think it's important under 8A, it was saying the rules of the department. It's actually the rules of the Department of State Health Services in that particular situation. This department's not putting out rules about the Dangerous Drug Act. If you go to page 19, a little more than halfway down, this is what we're talking about, person-first respectful language, in terms of where we change it so that the language reads concerning abuse, neglect, exploitation of elderly persons or persons with disabilities. And then, so there's a lot of text here, but there's only a few little changes kind of throughout this section. Just a lot of this is cleanup. So, any questions or comments? Bottom of page 20, under that subsection E, again, another statutory cleanup in terms of how we reference the statute. And there was changes this session to the Crime Victims Compensation Act in terms of how it's codified. So that just reflects that. Page 21, subchapter M, it was just complaints, and it only had a few rules, one rule, and then enforcement provisions that had a few rules later on. We've combined those two subchapters that kind of naturally go together, complaints and enforcement provisions. So another example of where we combine subchapters and kind of help make it a little more user-friendly. Section 116.120, complaints. It's not just complaints about standard care. We've now expanded that. The new sections, subsections B and C under this section, are implementing House Bill 2847, two of the sections. One other thing is about giving notice to the public and that qualified persons, including advisory board members and other licensees, may assist the department in reviewing investigations and complaints, and they would be immune from liability in their role in helping us do that. I think that's an important provision, making sure we have that expertise. People feel free to assist the department in providing that expertise. And then subsection C is the provisions regarding confidentiality of complaint and disciplinary action. There was a provision that was in the dietitian statute, and there were similar provisions in other healthcare professions that were transferred to the department. Some of them weren't always the same. So House Bill 2847 repealed those standalone provisions that were all in the different professions and moved it into our Chapter 51, which is our enabling statute for the department and commission. And so it's a standardized provision that applies to all those health provisions, and it made updates to those the disciplinary confidentiality information. And so this is just directing you back to our Occupation Code Chapter 51, the new Section 51.254. You don't think, oh, we lost it out of the dietitian statute. That's where it is now. Any questions or comments on that? Bottom of page 21, 16.121, administrative penalties and sanctions. This was former Section 116.130. There's no proposed changes to the text. Looks like it's due just because it's been relocated. That's the same also with 116.122 enforcement authority and 116.123 license surrender. These were formerly sections 116.131 and .132. They've just been relocated. And then you'll see kind of middle of the page on 22, subchapter N, the enforcement provisions. So those are all being repealed, relocated. Bottom of page 22, subchapter O, the dietetics profession. This is rule section 116.141, provider nutrition services. The proposed rules are updating the terminology in B and C to use gender neutral language. So you've got a lot of text with just a few little changes of the scope of his or her license. Now it's the scope of the dietitian's license. So you've got that in a couple places. Bottom of 23, 116.142, licensed dietitians providing diabetes self-management training. Again, this is gender-neutral language under subsection C, which ends up being lower third of the page on 24. And that is all the changes for this. If you have any questions or comments or?
So I have a question. For the jurisprudence exam, will any of these new changes be covered, or things that were taken out and revised? Do anybody checking those questions to make sure we're not, asking a question about something that we've changed now?
Right. I don't know if anyone from E&E is here would like to talk about updating jurisprudence exam.
Hi, Fanny Pringle with Education Examination. We recently, the last time we've updated, reviewed the jurisprudence exams for updates was this past May. Once these rules are finalized with board approval, and then we will have an ERC to do another review of those exam questions to make sure they're current and valid.
Madam Chair, members, Ray Pizarro, Director for the Education Examination Division. I'm surprised you didn't ask that question earlier, and I knew you were going to ask, so thank you. As you heard me tell you before and initially that we were going to make these changes, and that is still holds true, we have tabled that temporarily because of, we have to update our contract and an RFP, we have to put one out there with the vendor. So we can't demand the vendor to make changes for us at this time until we do that. So we're in the middle of a contract update, it's going to encompass other things, but yes, as Fanny said, we are going to do that, but we are sort of on a holding pattern until we get that done.
Thank you.
And you should have some time, just because right now we're bringing this to you. These haven't been published yet or have comment. In fact, these are still draft. They'll be, all the rules have to be reviewed by the governor's office before we publish them in the Texas Register. So once we have that, we can publish it if that's the recommendation of the advisory board. So if you have any questions or comments, and we're happy to take any recommendations.
Thanks for all your hard work.
Thank you. Thank you. This is definitely a team effort. And again, like with our bill invitation teams, we work, multiple divisions get together and bring their expertise and insight to this. So definitely a team effort on this, but thank you.
I would like to say that I appreciate the conciseness that you're working toward.
We are trying. It's going to take kind of a couple rounds of this, but yeah, definitely our goal. We want to make them user-friendly and readable.
So do we need to have a
Yeah, if the
recommendation?
advisory board is in favor of that, we would be asking for a recommendation from the advisory board to publish the proposed rules in the Texas Register for public comment.
I would so move.
Susie Williams.
Thank you.
Do I hear a second?
This is Letty Moreno Brown. I second it.
All right. All in favor?
Aye.
All those opposed? All right, we'll make the
All right.
recommendation.
Thank you very much.
So, aren't you doing H also?
Oh, yes.
Oh, wait, I'll wait till
Thank
you
you for
get all
reminding
the way
me.
back there, and then I'll call you back
Thank you
up.
for letting me know.
Gotta get your steps in today.
Usually when we're done with the rules, you're done. Yes, so moving to agenda item H, this is discussion of House Bill 2059 from this past legislation, possible appointment of new work group, or if there's an existing work group, that would work, but really want to discuss whether the required human trafficking prevention training, which we just talked about in our rules, whether that could count towards the required continuing education hours for dietitians. Like I said, this is affecting 10 of our health professions. It's a renewal requirement, but our executive director wanted us to discuss this with each of the advisory boards for each of the professions to have that discussion, whether they could count that as continuing education. And what I mean by that is with the statutes, the rules, or any national accrediting organization or something that's tied to CE for that particular profession. Would that be possible? Could they do that? And if they could, would you want to? Would you want to count that towards it? And if so, what steps would that take? What would that look like? And so that's what this is. I think there's a lot of issues to kind of wrap your brain around. If like, could we do this? If we could do it, would we want to? And if we would, what would that look like? How many hours would that count towards? What kind of education would that count toward? What kind of category? So I think our recommendation is to have this go to a work group and work with a work group of the advisory board, but you should also be working with TLR staff and probably across multiple divisions on that as well, because there's a lot of issues to sort through that. Right now, there's, as I was saying, it's still up in the air because this requirement will start September 1st, 2020, but right now there's not. I'm aware of they're in the process of still approving courses or what those rules would be. And so what those courses would look like, would that be something you'd want to consider it to be, you'd think that would count towards dietitians continuing education? So open that for discussion. And like I said, our recommendation is to send it to a work group because there's kind of a lot of issues to kind of sort through.
So I would say I think a work group would be real beneficial because then we could contact the academy and it'd be very nice to coordinate it so that if the state of Texas granted this, that also they could get through CDR a 1 hour approval also, or whatever the length of it
Right.
would be. So how many people would you like to have on that?
Well, it needs to be less than a quorum. So we've got, we have 9 on this board. So we need
Mary
3 or 4 would be
Winston,
good.
Currently, are you thinking, Wendy, the E&E work group?
I was leaving it open in terms of if
Or-
there are folks who want, if they want to appoint a new one, or if there's an E. I don't know what's
Okay.
pending in other work groups, or if the scope of those other work
Okay.
groups. So we kind of left it
I
open.
think-
So
yes.
it's up to you all in terms of if you
Could
think
we
it
find
would.
out who's on which work group?
Well,
Or
I
Madam
happen to have
Chair.
just been given the sheet of paper.
I'm not sorry.
So we have 4 work groups that are already assigned, and so number 3 is called Education and Examination Work Group. And so I feel like this would fall under that category, and the members of that are Susie, Letty, and we've got an open slot. Because, would you like to be on there also? Okay. So can we just use the work group that we already have assigned? And-
Madam Chair, did you appoint someone new to that work group?
Well, what it is one of the members is no longer
Yes.
on the, so
Yes.
we need to appoint
And that is your choice. Who did you want to put on there?
Irma
Irma,
Gutierrez.
okay, all right.
Just because she raised her hand.
I might regret that.
Tag, bing, you're it. All right.
Remind me again when this goes into effect.
It applies.
Something 2020.
Yeah, it applies to, for renewals on or after September 1st, 2020. So you're not required to take the course before that date, but come that date, it'll be for every renewal after that, on that date and afterwards. So,
Very
Okay.
good.
thank you.
Thank you. You had a lot to present. All right, so the next agenda item is the reappointment of the existing work group, which we just did, number 3. Am I supposed to go through all of these, all 4, to make sure that they're current?
David Gonzalez, that's appropriate. It's your prerogative. If
All right.
if everybody's forgotten what work group they're on, a reminder would be good.
All right. So we have an enforcement work group, and that's Susie, Leanne, and Letty. And then we have a licensing work group, Irma, Matilda, and Leanne. And then we just discussed the education and examination work group. And then we have a standard of care work group that is myself, Matilda, and Letty. Everybody still okay with those assignments?
Who was enforcement again? I'm sorry.
The 4th
Irma
one is
Gutierrez?
standard of care.
No, what was the first one, enforcement?
Oh, the first one, enforcement.
And who was on there?
That was Susie, Leanne, and Letty.
Thank you.
All right, very good. So let's move on to the next agenda item, and that is recommendation for any items for the next board meeting.
asking if she would send out the list of those current and newly appointed work groups.
David Gonzalez,
Angelica?
yes, we can do that.
Yeah,
Thank you.
will you send that to everybody? All right, no items for the next board meeting?
Well, Madam Chair, Mary Winston, all of Wendy's hard work, we can get updates from that. And we have the new work group, and between now and the next meeting, the work group needs to meet and kind of come back with their report on it. The rules that Wendy did go over, if we can move forward on those, we're hoping. We don't have anything set as where we need to like set that date for the next meeting, which I'm kind of going to the next agenda item, but G and H will come back in
bet.
reports and work that Wendy will do. So those should be on the next agenda, and anything else you have, if you don't have it today, you can always email advisory.boards@tdlr.texas.gov, and we can see about getting it on the agenda as well.
Very good, thank you. All right, so that brings up item number K, or letter K. So our next meeting, do you have proposed dates?
Currently, I was talking to Wendy earlier, and there's some magic she has to work with these rules, more that she's already done. And we would just like to, she'd want to give you a date to then have to move the date. And according to our bill implementation timeline, we're looking at between April 20th and May 1st, just to keep that in your presence. But we also could poll you closer to that time to get a more specific date, but we just wanted to kind of give you a time frame.
Yeah, once we have a better idea, once we have approval, then we can submit them to the Texas to publish, then we'll have a better idea of like when to bring you back. We don't want to schedule it now if, since we don't know exactly when we'll be able to submit them yet.
Yeah, so let's do the polling, because I think that worked pretty well to get us a quorum for this meeting, you know? So let's continue with that process so we can always have a quorum. That'd be great. All right, so do I hear a motion to adjourn? Hear a second?
Second.
All right, all those in favor? All those opposed? All right, we're going to adjourn.